Good morning, everybody. Thank you all for joining us. I think we've got almost everybody in from the waiting room. And so we're going to go ahead and get started. Thank you all for joining us today. We're happy to have you here with us. And as I usually do, I am going to go ahead and start us off talking about some Zoom housekeeping tips. So the first reminder is that we do ask that everybody stay muted during the Zoom Q&A. You're welcome to unmute yourself if you want to ask a question verbally instead of putting it into the chat, but keeping muted otherwise minimizes background noise and just makes it easier for everybody else to hear. If you're wondering where your mute and unmute button is, it's on your Zoom toolbar. Most devices, that's at the bottom of your screen. That's also where you'll find your start and stop video button. If you want to be on video today, we'd be happy to see you. But if you need privacy or just not prepared to be on camera today, feel free to keep your video off. That's at your discretion. That is also where you'll find the chat button, and that might be flashing for you because I did put a message into the chat. The chat is the best way to ask questions today or request clarification about something that we've talked about. And as mentioned in the message that I just put into the chat, if we don't get to your questions today, please email them to info@condolaw.net by 4 p.m. on Monday afternoon so that we can include them in our next Q&A. Although in this case, that will not be next week because we are not having a Q&A on July 3rd. So please keep in mind that we are not doing this Q&A next week. That's been canceled because the next day is a federal holiday and lots of folks are taking all of next week off. I hope that most of you are able to take some time off next week as well. So if we don't get to your questions today, you can email them to that info@condolaw.net email address anytime in the next 10 days, I guess, by Monday of the following week so that we can prep them for inclusion in the Q&A for July 10th. As we remind you every week, we are here to talk about general legal information, not to give legal advice. A lot of our questions this week, we're going to be repeating that reminder to you because folks are sending in questions asking us to interpret their particular governing documents or give advice for very specific sets of circumstances, and we just can't do that in this context. We do try whenever possible when those questions come in to include them on the list anyways, and at least talk about those topics generally in case that's helpful to the audience as a whole. But again, this is not legal advice. So number one, you can't rely on anything that we say here or that you see in the chat as legal advice. But also the good news is that somebody sends you one of our videos and says you have to do this thing or you can't do that thing because of something that one of us said. You can ignore them because again, this is not legal advice. We have also been talking a lot since this first started becoming a topic of interest about the Corporate Transparency Act, which of course is still being challenged on a number of different fronts nationally. And the more recent development is that this month, the Board of Trustees for CAI National, CAI is the Community Associations Institute, approved filing a lawsuit to specifically exempt and protect community associations from the requirements of the CTA. The suit challenges the Department of Treasury's restrictive obligations and underscores CAI's unwavering commitment, as they put it, to protecting the community association housing model and its members' interests. So a lot of folks wondered if the decision in the 11th Circuit that said the CTA is unconstitutional would result in a stay nationwide on the implementation of the CTA while the rest of that case makes its way through the courts. And instead, what ended up happening in that particular case is the court said, while we're staying the act, but only with respect to the parties to that litigation. So the hope, I think, is that with this lawsuit, in particular specific to community associations, is that at minimum it will result in a stay in the applicability of the CTA to community associations until that lawsuit reaches its conclusion. So a lot of our clients are, again, continuing to wait and see what happens with all of these different national efforts with regards to the CTA and are choosing not to start reporting now. We did, some of us attend a CLE at the state level about the Corporate Transparency Act yesterday. And there was one suggestion that we thought was really helpful and something for those of you to keep in mind who might be looking at this reporting requirement later in the year, which is that each individual person that is a member that would have to report under the CTA can go to the FinCEN website and enter your personal information to get your own FinCEN ID number. And when your association sets up and initiates its own reporting to FinCEN to comply with the CTA, it can essentially invite the individual board members to put in their ID number. And what that does is it means you're giving your personal information to the government only, which, by the way, they already have it all, and not to your community association. So if you as a board member are concerned about, giving a copy of your driver's license and all of that information to your association or to your management company to do that reporting, this is a way to allow the board members to do their reporting directly to FinCEN while also allowing the association to meet its obligation to do that reporting indirectly through the individual board members. So it was an interesting thought. We hope that this lawsuit results in, not having to follow through on that thought and these ideas, but something worth mentioning. We've also been reminding everybody that a lot of the revisions to WUCIOA that were included in the WUCIOA for All bill took effect on June 6th, so a little bit earlier this month. During the legislative session, I think a lot of folks got caught up in the WUCIOA for All part of the bill and the fact that it's now going to be applicable to everybody effective January 1st, 2028. But there are a number of revisions that were made and took effect this year for those communities that are already governed by WUCIOA. Those changes don't affect anybody else. They only affect communities that are currently governed by WUCIOA. They're not currently available on the legislative website. So if you do a Google search, if you Google RCW 649525, which is the budget ratification section, or any of the other sections of WUCIOA, the changes made in 2024 that are in effect right now are still not showing up there, but any of the sections of WUCIOA that were modified this year have a big note in bold caps on the top of the page of the individual section saying modified in 2024 and linking to the bill that was passed by the legislature and signed into law by the governor. So if you're a WUCIOA community, keep that in mind. If you're managing a WUCIOA community, keep that in mind. And we will be talking about some of those changes in the coming weeks and months, just as we ourselves become more familiar with them as we deal with them in our practice. I think that's all I have as far as announcements. I guess I will just remind everybody one more time that we're not doing a Q&A next week. So this canceled on July 3rd. We will then see you back here the following week on July 10th. And I think, Jennifer, you can just go ahead and take it away with our questions.
Okay, sounds good. Our first question this week is, I recently manage a new development. The declaration says that the association is responsible for exterior maintenance. What can be considered as exterior maintenance? Our usual disclaimer, we need to see the document to give specific advice. Typically, what the declaration is considering maintenance is defined somewhere in the document. We definitely need the at least the declaration and the maps to say what is and what is not required. We personally do not like the word maintenance because it can mean repair, replacement, or just cleaning and taking care of. So maintenance has many different meanings. So absent a specific definition in the governing documents, a court, when looking at this, would generally give the word their plain meaning. So exterior maintenance could include just landscaping. It can include siding cleaning, maybe repairs, roof cleaning, gutter cleaning, maybe repairs. There's no way to know. The second challenge is defining exterior. It can mean just paint and roofing material, or it could also include the structure. So how the unit is defined or how the lot is defined is extremely important. If the boundary is the unfinished surface of the perimeter unfinished interior surface, then the association is responsible for the exterior. And we ran into this earlier this week. If the definition of the unit boundary is the finished surface of the exterior walls, then it could be that the owner's responsible for the siding. So without having the documents, we can't know for sure. So if you need specific advice regarding what maintenance means for your particular association, you need to contact your association attorney and have them give you an opinion. Valerie, did you have anything to add to that?
Yeah, it's just, I mean, as you say, it's very document and fact specific. And we wish that there was, you know, a clear definition for all of these kind of random terms that come up in our practice area, where we could give the right answer that would be applicable to all communities. But just like things like the unit boundaries and the common elements and limited common elements are very community specific, they're different under each of the statutes, they can be different under the governing documents. That's exactly why we can't give a clear one size fits all answer to this question. All right, our next question is this. If a homeowner writes a memo on their check earmarking their payment specifically to pay for dues, but they have an older unpaid fine that they protested, but the board ruled against them, and payments are normally applied to the oldest charge first, what would be the best practice? So again, I'm going to start with the disclaimer. We cannot answer this question for any particular community, and the answer is not going to be the same for every community because it depends, at least in part, on what your documents say. It also depends a lot on the facts of the scenario, which I'll get into a little bit later in my answer. So the first thing I'm going to say is check your governing documents. Sometimes the declaration itself will specify how payments are to be applied. We know of another firm in our practice area that at least used to draft language that required payments to be applied in a very specific order, first to attorney's fees, then to late fees, then to interest, then to fines, and only after that to the unpaid assessments. And I never understood why they did that, because I don't think that's favorable to the association. But nonetheless, if that requirement is in your documents, then you need to be following it. That's not how we draft our documents. We generally favor applying payments to the oldest amounts due first. But I do think it's really pivotal here to state that there is a difference between what your documents require as far as payment application and what's your normal practice absent a specific requirement in your documents. In other words, the association has more of a leg to stand on in, for example, asking the owner to reissue a payment like that without the restriction, if there is a specific payment application method in your declaration and you're following it, versus trying to take that same action, require the owner to reissue the payment if there's nothing in your documents and they're silent and you're just relying on past practice to require the owner to do that. If an owner submits a payment specifying how it is to be applied and you deposit it, the risk is that a court might interpret that as consenting to the directive on the memo line. However, the flip side of that is if you return the payment to the owner and refuse to accept it at all, there is risk with that approach. And I think I also want to make a distinction here between rejecting a partial payment period versus returning the payment to the owner and asking them to reissue it without that restriction written on the memo line. We have had cases before, and Ken was actually talking with us in the prep session about a case that we actually took on behalf of a homeowner, one of the rare circumstances in which we do that, where their association was just rejecting partial payments outright, just rejecting them. If it was the owner's choice, as the association saw it, was pay in full or pay nothing. And that unfairly penalized the owner by adding late fees and adding interest in larger amounts than would otherwise have been the case if they had accepted those partial payments. And so you want to be careful about how you couch your communication to the owner if you do try to get them to reissue the payment. There's a lot of other factors that would affect our advice to a client in this circumstance, okay? I want to know, what is the balance due? I want to know the amount of the fine. I want to look at the fine notice and see if you actually gave the owner meaningful due process before you fined them. Did you follow the fine schedule in the amount of the fine? Has the violation been corrected? Because fines exist to prompt compliance, not to create an income stream for the association. And so if the fine was, say, a year ago and it was for $100 and the fine notice was perfect, but the owner has since corrected the violation, even though the association could probably make an argument that that fine is enforceable and should stay on the owner's ledger, I'm probably going to tell my client to waive it or leave it on the ledger and don't do anything else for now and see if they stay in compliance for the next year or two. I also want to highlight that there's a difference between what a board might be able to argue is reasonable in terms of this scenario versus what we can defend in court and what we can try to collect under the Fair Debt Collection Practices Act. So it may be that you have followed all of your processes correctly and that the fine is enforceable from an association perspective. That is not always going to lead to an attorney's ability to collect that fine. So there's just a lot of moving parts, a lot of specifics that matter here, and I can't give you an answer to what is the best practice for your community. If you're dealing with this particular situation, my recommendation would be to send a copy of the ledger and the fine notice to your association attorney and ask them how to handle it. And be very, very careful about rejecting payments from owners. I would absolutely consult with your association attorney before you decide to do that. Jen, did you have anything you wanted to add?
No, I think you covered it. So our third question, how can a single board member protect themselves from legal ramifications if an homeowner decides to sue the association because some protocol was not followed? So one overarching idea here is that board members, as long as they are acting within their statutory duty of care, they're acting reasonably, are indemnified by the association, and you would have no personal liability. That's what the corporate filing is for. The owner would sue the association. They could name individual board members, but unless there was some specific reason why the association's directors and officers insurance would not cover that particular lawsuit, they would have no personal liability. So with that overarching idea, again, we cannot give specific legal advice for your situation. We recommend you consult with an association attorney. And again, there's no way to completely remove an individual from the potential of getting sued. Anyone can sue anyone for anything. It's just what insurance do you have? So directors and officers insurance for a board member. We also recommend having insurance for volunteers or committee members as well. And your declaration will have specific language, or the vast majority of declarations have specific language regarding indemnification of board members, as long as that particular board member is acting within their statutory duty of care. So just kind of as a pin to this, if a board member is acting reasonably with the same level of care that a reasonable person would use in the best interest of the association as a whole, a court isn't likely to find that that particular board member has personal liability for whatever action the owner is contesting. So, and again, as long as you're acting within your statutory duty of care, your directors and officers insurance should defend, should a lawsuit be filed. And the liability is with the association, not board members directly, unless they specifically violate their duty of care. Valerie, did you have anything to add to that?
Yeah, I think, it's maybe helpful for us to say that, the firm has been in practice for over 20 years. I've been in practice for over 15 years. Jen, you've been with the firm for what, like, 7, 8 years? Longer?
I think I'm going on 8.
Okay. And I can tell you that I have seen individual board members named in lawsuits a handful of times. And I have seen individual board members held liable in those lawsuits 0 times in my 15 plus years with the firm. So it is true that anybody can sue anybody for anything, because all they have to do to file a lawsuit against somebody is pay a $250 filing fee and then file the document with the court. That's easy, but it's hard. You have a duty, a burden of proof that you have to meet with the court in order to actually hold somebody liable, personally liable, for whatever the thing is that you've sued them for. And that is a very, very rare outcome when board members, as Jen said, are acting within their duty of care. All right, next question. When an association is amending their CC&Rs and they want to change 2 or more items, does each item have to be a different amendment? If there is one amendment with multiple items, do the owners have to agree on each item, or do they vote as a whole on the changes? So the short answer to this question is you can definitely combine multiple purposes into one amendments. We have clients that do 2 and 3 purpose amendments all the time, but any more than that, and there's 2 things that happen. The cost starts to get to the point where you should start looking at putting that money towards a restatement instead of dealing with everything via amendment. And the other thing is that it can get confusing for owners to read and find the correct information and determine how they want to vote if the amendment tries to deal with too many moving parts at one time. Sometimes it's harder to get a large enough percentage of owners to agree to a multi-purpose amendment than it is to get them to agree to 1 or maybe 2 things at the same time. So keep that in mind too. It may depend on exactly what it is that you are trying to amend the documents for. And sometimes it's helpful to take the pulse of your owners ahead of time to see what type of amendment they might support as you determine your strategy for doing the amendment. There is statutory requirement that any proposed amendment has to set forth the proposed text of the amendment. So you have to send the whole amendment to the ownership ahead of time. And whether you're doing a meeting for the vote or voting by mail, you have to send them the text of the amendment so that they have a chance to look at everything that they're actually voting on. I just put the statutes for that in the chat. And we do have clients that sometimes allow owners to vote separately on distinct pieces of a multi-purpose amendment, just in case there is enough support for 1 or 2 sections, but not enough for a third. That allows you to at least pass the parts that you do get the support for, rather than having the whole amendment fail because people don't like one piece of it, right? Like maybe you're doing a rental amendment, which is sometimes a type of amendment that can be a little bit unpopular and harder to get support for. But you're also dealing with things like, I don't know, electronic meetings or other amendment types that would have more popular support within your community. Allowing owners to vote on each topic separately allows them to support the things and for the association to pass the amendments that the owners do support without having the whole thing fail because of one thing that the ownership doesn't like. I do think that it's worth noting that there are a number of technical requirements that are part of the process of drafting a valid and effective amendment. And I have not ever seen a layperson draft an amendment that did not require changing when it came to an association attorney. So we strongly recommend that if you have a community that's considering amending their documents, that they work with an association attorney to draft it. We do often have people come to us and say, well, what if we draft it and just have you review it? Isn't that cheaper? And the answer to that question is categorically no. It is almost always more expensive to review and fix an amendment drafted by a non-attorney or drafted even by an attorney in a different practice area. What we do is ultra specific. A lot of people, I had a friend the other day that was like, I know that you're a commercial real estate attorney. I was like, that's not at all what I'm not at all a commercial real estate attorney. And even though it would seem that there might be some overlap because what we do pertains in some ways to real estate, meaning real property, the best real estate attorney out there, if they don't have community association specific experience, would be unlikely to draft an amendment that did not need revising to comply with the technical requirements that we deal with every day. So that's a lot of information, but the short answer is yes, you can do more than one topic per amendment, and you can allow the owners to vote on the entire amendment collectively or on different pieces of it separately. And your association attorney also will have advice for you on how best to approach that voting. based on the topic of the amendments and their experience with other communities dealing with some similar scenarios. So Jen, I don't know if you have anything to add to that.
Not to that one. So the next question, I have an association with an upside down flag displayed. I know you have addressed flags in the past, but I don't remember an upside down flag being addressed. What action can or should the board take? So I had to do a bit of research for this one. Flags are regulated under 6438.033 and 6490.510 sub 1. So for right now, for condominiums, flags are not regulated within the association. However, in 3 years, they will be. So we recommend you start adopting and following WUCIOA, even if it isn't applicable to you now, it will be in 3 years. So as a rule, you can require that individuals who fly the American flag comply with the U.S. flag code. The flag code is what's the word I'm thinking of? It's not mandatory. It's a regulation for how it should be. It's not, there's no fine or criminal liability for not following the flag code. So the flag code itself allows flying the flag upside down in situations of, and I'm quoting the statute, dire distress and instances of extreme danger to life or property. But flying the flag upside down has been used as a political protest for both sides of the political spectrum, both liberals and conservatives, both sides have used it. Honestly, we do not believe it's worth the fight and potential publicity to enforce and try to either have someone take a flag down or fly it right side up. It's just not worth the fight, especially since there's no criminal liability for it. And honestly, there are other things the association should be concerned about.
I'll add to that because some people might be like, well, what do you mean publicity? You know, as an example, a number of years ago, we had a client where a homeowner was flying some bananas gigantic Seahawks flag. I mean, it was like 50 feet. It was crazy. It was huge and it was right on the lot line. So it was very clearly visible and, you know, flapping out over the common space within the community. And it was, I think, a Seahawks flag, and they were flying it 24/7 during the season. And the association tried just to limit the owner to flying the flag on game days. And by the time the news media got a hold of the story, it had turned into a story of an association refusing to allow a United States military veteran to fly the American flag. So even though you may not think that what you're doing is at all sort of bad publicity, things end up getting twisted sometimes by the time they are publicized by the media. So we just think that a situation like this is where the association's energy is better spent in other ways.
So the next question, when the board decides to have an amendment created, do they go to the association first and vote, then have the amendment written up, or do they have the amendment written up and then present to the owners? So our general recommendation is to have the amendment drafted, the board approve the draft, and then send the actual amendment language out to the owners for vote. So owners will be able to actually read the amendment and know what they're voting for. 6490.445 sub 1C1, and Chelsea, would you mind putting that in the chat? Requires the text of any proposed amendment to the declaration or organizational documents to be provided with the notice of meeting where it will be discussed. And then I think Valerie already put the citations to all 4 common interest statutes. All state that when a vote is done without a meeting, the ballot must set forth each proposed action and provided the opportunity to vote for or against. If you want to take the pulse and kind of see where if your owners are interested in a particular action or particular amendment, you can just send out a poll, or you can solicit owner feedback before the amendment is drafted. It would basically be an advisory vote and could not count towards the required percentage to pass the amendment. Valerie, did you have anything to add to that?
No, I think you covered it. All right, next question. Our HOA is faced with the issue of a request for accommodation via Zoom to attend our now monthly business meetings. Since COVID and up through June 2024, Zoom has been offered as an alternative means to attend our then quarterly business meetings. Zoom was canceled in a 4-to-1 vote this month. The option of telephone conferencing has also been rejected by the board of directors, although not yet presented at an open meeting for voting. So there's not a question here, but I assume the question is, what do you do and how do you handle the request for accommodation, right? And I think that I have to start by saying that we cannot address the specifics for a request for a reasonable accommodation in this forum. You need to contact your association attorney to get advice on how to proceed before the board makes its decisions on this scenario. I will say and remind everybody that all of our statutes were amended in 2021 to allow for virtual meetings, even if the association's documents were silent or prohibited them. And there's a part of me that was reading this question and thinking, like, why are you making attendance at a board meeting more difficult for both owners and board members? If you did it via Zoom for 3-4 years, why is the board going back to requiring in-person meetings now? And there's a part of me that wonders if this might be being used as a means to prevent or limit owner attendance or review. And if I'm thinking that, then it's very possible that a court might view it that way if you close the meetings or remove the virtual option and the owner in question challenges that action. If the owner has a disability and they request this as an accommodation so that they can attend open board meetings, we would probably tell a client that that accommodation needs to be made. Even if you decide to hold the meetings in person, if the board decides to hold the meetings in person, it's not hard to open a Zoom window and have Zoom as an option so that people can listen to the board meeting virtually. The answer would also probably depend here on whether open meetings are required under your applicable statute and governing documents. If the meetings can be legally closed, then that might mean no accommodation is required. But two things on that. Number one, it's only a temporary solution, because even if you're not required to have open board meetings now, you will be in 3 years when WUCIOA becomes applicable to everybody. And the other thing is, you can't say, well, we're not required to have open meetings, so we are not required to make this accommodation, but then keep the board meetings open to other owners who are willing or able to attend in person. You can't have it both ways. So I'm just a little bit baffled about the fact pattern here. And if I were working with a client and there, all other things being equal, there's no extenuating circumstances that I'm not aware of, I would be telling why are you requiring in-person board meetings? And why are you refusing to allow a telephonic or Zoom option for an owner who needs that in order to be able to effectively observe your otherwise open meetings? I think this was a two-part question. The second part of the question is, our board is also taking the position that the Federal Fair Housing Act does not apply to HOAs. I'm hoping this question might be discussed at an upcoming law session. Your board is wrong. There is very clear case law that says the Federal Fair Housing Act does apply to all community associations. They might be getting it confused with the ADA. The ADA does not apply to most HOAs, but the FHA absolutely applies to HOAs and condo associations. And part of how we know that, other than just the case law, is that we've also worked with a number of clients that have been the subject of a resident filing a complaint with the Department of Housing and Urban Development, which is the federal agency that sort of administers the FHA. And that results in an investigation at the state level by the Washington State Human Rights Commission. And these investigations begin with a near assumption that the association has acted in bad faith and has discriminated against that resident. And it's very difficult to prove otherwise. So we work really proactively with our clients to get them to comply with the FHA and try to avoid the complaint process entirely, We don't even want it. We never even want it to get that far. Number one, because it's the right thing to do. And number two, because that investigation process is generally unfavorable towards the housing provider, which in this case would be the association. If this board claims the FHA does not apply to them, you should tell them to ask their association attorney for an opinion on that. You should also tell them or encourage them to become WSCAI members so they can take advantage of the many educational opportunities that are offered through that organization, including FHA related stuff. For those that don't know, WSCAI is the Washington State chapter of the Community Associations Institute. You can go to their website at wscai.org and maybe send that to your board and ask them to consider paying for a membership for at least one board member so they can get the journal, which comes out, I think, every other month, as well as have access to lots of free members only educational opportunities and other low cost members only educational opportunities. But they're absolutely subject to the FHA, and I would be very concerned if a client came to me with questions like this, and I would be giving them very blunt advice, like I'm not giving you advice, but being very blunt anyways right now. So Jen, did you have anything to add to that one?
Just briefly, I think we also have a couple chapters in the books that we've put out in 17 and 19 about reasonable accommodation, and those will go into what the FHA requires. So if you look on our website under resources, it should have a link to PDFs of the book chapters. So just double check there as well. It's free for anyone to take a look at. We may still, I don't know, do we still have copies of the 19 book? I don't know.
I don't think we have any physical copies left, but I just put a link into the chat for our handbooks, and you can link the PDF for the 2019 and 2018 books using that link.
Okay. So the next question. We have been approached by McDonald Miller regarding the Washington State Clean Building Bill. In reviewing RCW 1927A210, we wonder if this even applies to condominiums like ours. Several board members and I have read up and are not sure as the information online seems contradictory. So again, we can't give legal advice or specific advice for your situation. So 1927A 200 sub 7 and 200 sub 26 could impact certain condominiums, but 1927A 210 sub 3 states that the State Commerce Department, sorry about that, must develop a database of buildings affected by this statute and notify the owners of the buildings that compliance is required. So if you have not received a notice from the State Commerce Department, you may not be affected. It would be a good idea to contact the department and make sure. You can also Google the Washington State Clean Building and the Commerce Department website with a specific page for the clean building section should pop up. And that's how I found this information yesterday anyway. Valerie, did you have anything to add to that?
I do not. And I'm going to keep us moving because we have lots of questions left. So the next one is, I noticed some errors in our 2024 annual meeting minutes, which will be approved at the next annual meeting. I asked the secretary to make the corrections and present them at our next regular meeting. I'm assuming this means the board meeting, to see if all errors were made correct. The president said, no, we can do them at next year's annual meeting. Is this correct? The short answer to this question is yes. Generally, you wait until the next annual meeting to revise and then approve the minutes from the previous meeting. I will say that if you are an HOA governed by the HOA Act, and I'm going to put the section in the chat that's relevant here, this section does state that minutes from an association meeting have to be made available to the owners no more than 60 days after the meeting. But the meeting minutes are not approved until the next association meeting. So essentially what you are providing to them is a draft, and you should just clearly mark it as a draft. Draft minutes remain draft minutes until they are edited and then approved at the next meeting of that same type, right? So this is an association meeting. It's probably a good idea just to wait and do all of the edits at the same time, so they're all in the same record. But If there are significant and clear errors in the draft minutes, we might recommend that at least a note be added to the draft saying that, this is an error that's going to be corrected at the next annual meeting. But it's also possible that the board does not agree that there are errors, and the full association is the group that gets to decide if that's the case. So you might think that it's very clear that there were errors, but if the board doesn't agree, and if the next annual meeting isn't until, a year after the last one, I'm not sure there's anything that an owner can do to try to force those changes sooner. Jen, did you want to add anything to that?
Just briefly, and honestly, this goes down to how you draft minutes. Minutes are a reflection of what happened at the meeting. It's not a verbatim report of proceedings. So it should just be what votes were taken and the outcome of those votes. And it can be as simple as that. You might add more information if you want, but they should be very succinct and fairly simple, just because you want the record of what happened, but you don't want extraneous information because it's not necessary, number one. And number two, it's a record of the association. So anyone can go back and look at that and say, well, this was brought up then and you didn't do anything. So if it was just a quick topic of conversation, determine whether or not you want that in your minutes, but it's really not required.
The second part of this question is, what if that secretary that took the minutes resigns prior to the next annual meeting? Can the meeting still take place on that day? The answer is yes. The secretary resigning doesn't change anything. You still have the next annual meeting as planned. Their resignation doesn't change that process. If they resign, let's say in between 6 months before the next meeting, then the board just appoints somebody to fill that position until the next election, or they can decide to hold an election mid-year, I guess, if they want to replace that person. But the presence or absence of the person who drafted the minutes does not change holding the annual meeting, making any corrections that might be necessary, and then approving the minutes as corrected at the next annual meeting.
So our next question, if the bylaws have a spending cap for the board and a repair needs to be done that exceeds the spending cap, what should the board do if the membership doesn't approve the expense? What are the pros and cons of spending caps like this? So back to our usual comment, we need more specifics and we cannot give legal advice for your specific situation. So this is just going to be very general. In most associations, the language that you're referring to references capital improvements, not repairs. Capital improvements are something completely new that the board or association is going to add. It does not mean repair, replacement of existing thing or component. And there is a case on point for this. It's Elmore Ridge. There is no limit on what the board spends to repair or replace existing building components like a roof. So if the association is an HOA under 6438, WUCIOA specifically wiped out any limits on budgets and what can be spent. You just have to follow the budget process in 649525. The community can reject the budget, but they don't need to approve the budget. So and just in general, the budget is a best guess. The board can reallocate spending as required to meet actual expenses and requirements. If the component needing repair is on the reserve study, you can use reserve funds to repair or replace that particular component, and you don't need to go through the process of getting approval of the owners because it's a repair to a reserve component. If you need a special assessment to pay for the repair, you would need to follow the special assessment section in 649525 sub 3. So there really is no reason why the board can't make a needed repair. If you do a special assessment, the association has to ratify the special assessment budget, but you can pull from either another budget category if required. You could potentially decide not to make reserve contributions or deposits into reserve to pay for that particular repair, or pull money from reserves if it's a reserve component. Valerie, did you have anything to add to that?
I do not. I'm going to move on to our next question, which is, are managers required to attend board meetings and owner hearings? So there is no statutory requirement for managers to attend either. And the obligations of the manager and the management company are spelled out in the management contract. So you need to look at your management contract to see whether it includes manager attendance at things like board meetings and hearings. Sometimes the contracts are specific enough to even spell out whether whether the manager is going to take minutes or whether that is an obligation that will be retained by the board. This is one reason that we recommend to any of our clients, if they're switching management companies, we recommend to them that they have us review their management contract. Mostly it's to make sure that boards understand what it is that they're getting and how much they're going to pay for the services that they want. All of that being said, many governing documents do allow the board to delegate, for example, the hearing process to the manager. Many boards delegate the responsibility of running the board meeting to a manager, and that's perfectly acceptable. And in addition to that, the manager might be the person who is best equipped to present evidence of a violation or the enforcement process in order to allow the board to make an informed decision about whatever issue it is that they're discussing. So let's say we're talking about an enforcement decision and it's a hearing, and the board after the hearing is trying to make a decision about whether a violation occurred, whether a fine should be assessed, etc. Depending on the subject matter, the manager might be necessary to the board so that the board can rely on objective information and make a reasonable inquiry into the matter rather than trying to make a decision without the information available to them through the manager. So we frequently see managers attend both board meetings and hearings. There's not usually a requirement. Their absence would not negate the outcome of the hearing, for example, or the authority of the board to make decisions at their meeting. But as a practical matter, sometimes the manager really is a necessary party because of whatever the thing is that's going on. So, Jen, did you have anything you want to add to that?
No, I don't. Next question. A homeowner wants to install solar panels in an association. Their unit is a 0 lot line unit with a shared wall and roof. The panels are all going to be on the side of the installing homeowner's roof. Do shared roofs pose any problems with installing solar? Separately, what if there was a scenario where the optimal sun was on your neighbor's side of the roof? So solar panels are regulated by 6438-055 and 6490-510 sub 3 and sub 5. So for condominiums, this doesn't affect you now. It may in 2028. It really depends on the language in your governing documents. So shared roofs aren't a problem. Owners can only install panels on property that they own. So for the example of the better sun being on the neighbor's roof, the owner requesting solar cannot do that because they don't own that property. So the ACC or architectural control or the board can make certain regulations regarding solar and require an application and approval of the board. That's in statute. And there are some things that the board can regulate, but only as provided in the statute. You can't just outright prohibit them. We would also recommend that if the association has any responsibility for repair, replacement of the roof or potentially siding, that the association get a hold harmless agreement from the owner stating that they're responsible for any damage arising from installation and that the owner is responsible to remove when the roof has to be replaced. Valerie, did you have anything to add to that?
I do not. So I'm going to move on to our next question. Is there a place that tracks the changes the legislature has made to WUCIOA since it was enacted July 1st, 2018, that will apply to other communities on January 1st, 2028? Also, which changes apply immediately? There is not one website that tracks all the changes since 2018. However, if you look up WUCIOA now, well, not right now, because the 2024 changes haven't been added to the legislative website. Once the 2024 changes are added to the legislative website, that will be a complete encapsulation of WUCIOA as it exists today. And that's the statute that applies to everybody governed by WUCIOA right now. And that will also be true in 2028, meaning the then version of WUCIOA, which is going to apply to everybody, you'll be able to find on the legislative website at that time. So it's not going to be, I'm just a little bit confused about the wording of the question. And I want to make it clear that the whole of WUCIOA as it exists on January 1st, 2028 is what is going to apply to everyone. And the other thing that will happen is that the HOA Act, the old Condo Act, and the new Condo Act will essentially be void from that day forward. So it's the whole statute as it exists at the time that it becomes applicable to everybody that you're going to be concerned with. One thing you can do is if you're looking at a particular section of WUCIOA, it will note at the bottom if it was amended since 2018, since it was enacted in July 1st, 2018. If that section has been amended since the statute was enacted, there will be a note of the most recent amendment below the text of the section that you're looking at, but it will only say that it was changed, not how it was changed. In order to see the previous version and compare it to the current version, you then would have to look at the bill from whatever year that it was changed. All of the substantive changes to WUCIOA that were made by the legislature this year took effect on June 6th of 2024. There's one that's delayed until January 1st of 2025. I can't remember which one that is. But almost all of those changes are already in effect for communities currently governed by WUCIOA. None of the changes from this legislative session to WUCIOA apply to non-WUCIOA communities yet. So the parts of WUCIOA that applied to everybody still apply, and those parts were not changed. So the reserve study section, the budget ratification section, those are the ones you have to be concerned with as a non-WUCIOA community. The one way that you can see all the changes that were made in 2024, at least, is to go to the website for the bill that was passed. And I'm putting a link for that into the chat. If you click on that link, it will take you to the text of the 197-page bill that includes the part saying WUCIOA is going to be applicable to everybody, but it also includes all of the sections of WUCIOA as it exists right now that were changed, and it tracks those changes. So if you see large blocks of text that just look like normal text, that means those particular sections weren't changed. But if there's strike throughs or bolds and underlines, those are the parts that were changed this year. The second part of this question, I think, is related to the fact that WUCIOA is eventually going to apply to everybody in 2028. And the question is, since our community will not be able to waive an audit after January 1st, 2028, will our first audit be for the year 2028? And I think the answer to that question is no. Your first audit will be for the financials of the year 2027, because on January 1st, you will be required to have an audit. That's a requirement you will not be able to waive. And in 2028, the only thing you can audit is the previous fiscal year's financials. An audit is never for the current, ongoing, open, not yet finished year. It's always for the previous fiscal year. Most of our communities, their fiscal year runs from January till December, with the calendar year. If your community has a different fiscal year, then you would be auditing the most recently closed or completed fiscal year. You can't do an audit for the current year. You can only audit past years. And many CPAs will tell you that they need a firm point of beginning and will require going back further than 1 year. So if you are in a community that has made it a habit every year of voting to waive audits, which, by the way, is the only way you can waive an audit. Every year you have to do that vote. Then you might want to reach out to a couple of CPAs, get an idea not only of what the cost of an audit will be, but what type of look back period they are going to want and what that cost will be for you in the first year, so you can budget for it appropriately. Jen, did you have anything to add on that one?
No, I don't. Okay. So the next question, some of in our community have challenged the idea that if their assessments if their dues and assessments are not paid on time, they're not allowed to vote in the trustee election. In our governing documents, an active member is defined as someone whose annual dues and assessments are currently paid. Also, the bylaws say participation in the activities of the organization are restricted to members. We are trying to confirm whether or not our governing documents can allow us to remove voting privileges for failure to pay on time, or if there's any state law in Washington that makes our governing rules problematic. We have read in other states, California maybe, it is not legal to tie voting privileges to payment of membership fees and dues. So again, we can't give you specific advice regarding your documents. You are correct in California, you cannot restrict an owner from voting over non-payment of assessments. In January 2028, so when WUCIOA becomes effective for all communities, that will also be true for all communities in Washington as well. So the particular statute is 6490-405 sub 2 sub X sub 2. It prohibits owners from suspending an owner's right to vote for unpaid assessments. So even if you're not currently subject to WUCIOA, we don't recommend suspending an owner's right to vote. And honestly, we don't understand why this is a favored way of associations to try and keep people paying assessments, because all you're doing is decreasing participation. It doesn't change quorum requirements. It cannot change percentage of approval requirements. It's hard enough to get people to vote anyway, so why restrict someone from voting, period? Valerie, did you have anything to add to that?
No, I think you said it perfectly. All right, next question. I'm going to paraphrase this question because it's extremely long. If a board votes to go into closed executive session, do they need to disclose if they allow non-board members to attend? For context, our board voted to go into executive session to address a claim of owner-on-owner harassment, and then made a decision in the open meeting to have an attorney write a letter. There's a whole lot of questions basically, but the question really boils down to what are the best practices for this type of incident? And I want to say really clearly that we cannot address this situation specifically. If you've got this situation in your community, you need to consult with your association attorney, which it looks like your board has decided to get the attorney involved to write a letter. Hopefully they'll take a deeper look at the situation and steer the board differently if their approach has not been correct up to this point. I do want to highlight that there's a difference between executive session and a hearing, and executive session is not a hearing. And executive session is also not where the board should be voting on taking certain actions. Executive session is for a discrete set of topics that is much shorter than most communities think that it is. And then once the board is done discussing those things, with very, 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 very limited exceptions, they have to then come back into their normal board meeting, where that is when they then make motions, vote on how to take action, and record those decisions in the minutes. There are statutory provisions that affect violations, and I'm going to copy and paste those into the chat for you. You can look those up and see if the particular scenario that you're dealing with was handled in compliance with these sections. If you're fining an owner, that has to happen only after they have been told that they have the right to request a hearing about the violation and the fine. There's too much that we don't know here for us to comment any further, but I did just want to highlight the difference between executive session and a hearing. I wanted to talk about the due process requirement, and I wanted to make the recommendation that if a board is handling a harassment claim between homeowners, that used to be something where we would mostly say it's just an owner-to-owner dispute, you don't have to get involved. That is no longer the case. And if that is the situation that you're dealing with, I strongly urge you to have the board consult with their counsel about how to handle it before they step in the mud, so to speak. Jen, did you have anything you wanted to add to that one?
No, I don't, and we're right at 11.
Yeah, we're out of time. I apologize that we didn't get to any of the questions from the chat, but we will have those to, I guess, seed questions for week after next. Please don't forget that we won't be here next week. Have a happy 4th of July, and we'll see you guys in a couple of weeks. Thanks, everybody.
Thank you.